There you
There you
go.
go.
All right.
We are live and recording.
So I can call the meeting to order.
Are your tape
My name
recorders
is-
on?
My name is Dave Berry, I'm the chairman of the appeals board. To my right, we have Richard Nelson, to his right, Walter Hoffman. It's a three board panel, so we do have a quorum. And what I'd like to do at this point is, if parties from each side would kind of announce themselves and let me get their names down so I can write those down. So we can start.
Sure, I'm Paul Driscoll. I'm aware Norman has from Detroit and represent the opponent, Timberline PH. And Rick Benton is from Mainland.
And good evening. My name is Jim Katsifikis. I'm the attorney for the town of Newry, here representing and advising the Board of Appeals, and with me is my associate Teddy Simpson, who with the law firm of Perkins, Thompson, and Portland.
All right, Loretta Powers is our town clerk, Joel Corey is our code enforcement, Amy Henley is our recording secretary today. We have meeting minutes from the last Board of Appeals meeting, which we all got sworn in for. Can I waive the reading of the minutes for approval, or should I go through them?
You can ask it, it's completely up to you, Mr. Chairman.
Well, I don't know if this came with their packet or not.
It did not.
It did not, okay. Well, we elected officers at our last meeting, which was on July 2nd. Lucky me, I got elected as the chair. Walter was elected secretary and Richard was the vice chair. The new business was the village at Timberline, which we're talking about tonight. We got a little bit of paper to go over the last few weeks. Joel verified Exhibit E has been removed from the packets as the letter was submitted after the planning board made their decision. Joel explained the date on the 2025 UDRO was blacked out, as well as the definition change that was passed at the town meeting on May 13, 2025, as the application is based on the 2024 UDRO. So that was not in effect at the time. Joelle kind of explained, where she stood on this. She could talk to us about how things work, but not about the case itself. So, it was a 20-minute meeting, and notices have been sent to abutters, public notice has been published, public hearing has been advertised. We made the motion to adjourn at 1:18 p.m. For a 1 o'clock meeting, and we were seconded, and the next meeting is right now. So I can vote to approve the, motion to approve the meeting minutes from last meeting.
Seconded.
And we have a second, all in favor?
Aye.
Okay. Approved.
David, can I slow you down?
Yes,
On the back of those minutes is a place for each of you to sign.
yes, there
We
is.
need a copy of that.
Right
signed.
now?
Yes, please. And you can give it to Amy.
One copy.
Oh, yes, sir.
Quick question, are people participating by internet, attending this meeting by internet?
No one has requested that of the town.
Okay.
It can be viewed, but,
Later.
it isn't live.
I don't know what TV works. I just was shown how to operate the camera. That's all. Okay.
We won't have any remote participation.
I was gonna tell you that the reason I wasn't starting is because I'm a little bit too close to it, because that's what I do to technology. If it doesn't work, I back up and it's fine.
It's fine. Good.
All right.
Brooks hasn't texted me yet, so it must be working.
You all set? Okay. Then we have a list on our agenda of correspondence received. Now, this is correspondence received,
In the official record.
okay, so this is already in this. Can I ask why it's in, this is what we're going over, each one of these things? No?
It's just so that you have a record in the agenda of everything that's in your packet that you received on the 2nd.
Okay, okay. So, redundancy, I think, okay. Old business, there was none. New business, Village at Timberline, planning board application number 25/286 at 8 Timberline Road, Newry. Chairperson gives a statement of case.
That's you.
That's me. We have been asked to go over the finding of facts for this thing, and we have done that. I have done that, and I think we've all done that, and we've, written some things down. One thing that I would like to say, there's a lot of information that goes into a few short meetings, and unfortunately, those questions that get asked, it might go up to an engineering firm to come back, and they get back to you in a month, and then you almost skip a meeting before you get that information back. I tried to list things down chronologically when questions were asked or concerns were raised, and then when you guys got answers to those questions, how far down the road you got, answers to those questions, but, and it does take time. There was an awful lot of information in this subdivision, and like all of them, it does take time. And I looked at all, and we still haven't received meeting minutes from the last couple of planning board meetings in our packet.
You have everything that pertains to this record for
Okay,
Timberline.
okay,
The planning board has not had any other business for Timberline.
okay, so even though they had meetings after,
Correct.
okay, that's good to know. So, the planning board voted this thing, down, for a few reasons. Roadways being a big one. And I went through this thing, and every place they referenced, not this, they referenced the UDRO. You can go back and look up what you have to meet for criteria, and, I mean, to me, that there were things that weren't met in it, and I think that's why the planning board voted it down, and I think tonight we're here to listen to the rebuttal on that thing a little bit, and see what they have to say.
Perhaps I could help set
Yeah.
up the process for you, because I know this board hasn't had a chance to do it.
Believe me, I'm not a Robert's Rules of Order guy, or,
Nope, and I don't
it's
want
not
to
what I
be.
do for a living.
Understood. And we're not going to be hyper-technical, at least I don't think we are. I think we want to get some common sense here. But basically, yes, this is an appeal of a decision by the planning board denying major subdivision approval for the Timberline project. The application was submitted back on March 5th. It was determined by the planning board to be complete as of April 2nd. There were intervening meetings, but on May 7th, there was a site visit, site walk, and there also was a public hearing. And after that public hearing, the board went into deliberation, and it made its decision with regard to the 4 findings and conclusions on road issues that are set out. And then on May 21st, it adopted the actual written decision that documented all of that decision. So what you have before you in that big notebook is, for tabs 1 through 7, it is all materials that have been before the planning board. Under the UDRO, for appeals to this Board of Appeals from planning board decisions, the planning board has to submit the record of what it received. And so that's what it sent to you. The 8th item is the appeal. Technically, it's not in the record, it's generated the appeal, but that's in there, in the notebook, because the code enforcement officer was trying to get a packet out to each of you, so you have the packet all in one notebook. It's tabs 1 through 7 that are the record of the planning board decision. Tab 8 is the appeal. So tonight, as an appeal, this is a board with somewhat limited jurisdiction. You're not hearing this all over again. When it's a decision by the planning board, you review it on an appellate basis, meaning you're like the Superior Court. You're looking to see, did the planning board make a mistake of law with regard to the ordinance or state law? And are there factual findings supported by substantial evidence in the record? And you look to that record to see if there's evidence to support the decision they made. and if it's the sort of evidence that people rely upon in the conduct of serious matters. So that's your job. The parties are not to submit new evidence to this board.
Okay,
That's also under the U.H.A.T in Section 7 and also under your Board of Appeals ordinance, because you have both the Board of Appeals ordinance and the U.H.A.T Section 7 governing it. Please.
don't finish.
No, it's just, so no one submits new evidence on the basis of what was in front of the planning board. Did the planning board make a mistake of law? And is there a decision supported by substantial evidence in the record? And you are to hear an oral argument from the persons here. It's a public hearing, the public may speak, but they can only speak to what's in the record. No new evidence comes in.
Okay.
It's just argument.
So we can take these finding of facts one by one and,
We can. There are a couple of things at the very, very beginning that I'm going to ask and I'm going to lead you through for findings and conclusions, and it's just on routine things like jurisdiction, standing, and timeliness.
Yes, and also I want to talk about the standard of review and what you just said too, so.
Can we first go through jurisdiction?
Sure.
Okay, a Board of Appeals has jurisdiction to act on zoning matters, but also anything else that a municipality gives it by ordinance. And here, the Board of Appeals ordinance and U.H.A.T give this board authority to hear appeals from planning board subdivision cases. So my request to you would be, could we have a motion to determine that this board has jurisdiction to hear this appeal?
We consent to the notion that the board has jurisdiction.
Just want to technically get that motion made.
okay, so I'll make a motion that we have jurisdiction.
To hear the appeal. Okay,
In
and,
favor?
Aye.
Okay.
all right, the vote?
They did.
I'm sorry, put my head down. The next one is standing, and it's also an easy one. A board's not supposed to make decisions in the abstract. You're supposed to require an actual dispute with people in front of you who have standing, a right to be before you. And the applicant here, I believe, has a right to be before you. And so I would ask for a motion that the appellant has standing to bring this appeal and to be before the board.
Okay, I'll make a motion that
We agree with
they
that.
have a right to be here.
Yep.
And second appeal.
Okay, we have a second, and
All those in favor, yep.
okay. Last routine motion. In order for an appeal to be brought to you, it has to be brought within 30 days of the decision appealed from. The date of the decision is May 21, and the appeal was filed on June 17th, which sounds like it's within 30 days to me, but if you'd like to find that the appeal was filed on a timely basis, I'd ask you to make that motion.
I'll make a motion that the appeal was filed on a timely basis.
I'll second that motion.
Favor?
Aye.
All right, I think that brings us to the standard of review.
Right, so, in appellate procedure before appellate bodies, there's two kinds of review. One is called de novo, where you have like a whole new hearing, and you start all over again if you want, and consider new evidence and go forward. The record in this situation is appellate, so what that means is that this board reviews the decision of the planning board on legal and factual matters. Legal matters are given, determinations by a planning board about a legal matter is not binding on this board if it has a contrary view. Right? Legal matters are always subject to going further up the chain, either from here to Superior Court or the Maine Supreme Court. Factual determinations are given deference. Right? So, and I think before we get too far along, I'd like to have Jim tell me if he disagrees with what I'm saying.
I generally am in agreement.
All right, okay.
We'll worry about the details later.
So the issues, our contention, and it's very important to understand this, is that there's really no factual dispute concerning the layout of the properties, right? Everybody knows what they look like. They've been shown at length. They're detailed. They're highly, and the UDRO is the legal overlay that lays on top of this. And from the UDRO and the undisputed factual record, the planning board made decisions. this application, our contention is that each one of those was legally wrong, okay? So you say, well, you know, they had it in front of them and, you know, there was evidence. There's no dispute about the evidence. It's all about legal determinations, all right? So if there's further appeals from, you know, today on either side, the next level of review in court would be the same. It'll be straight legal determinations. No initial determination by the code enforcement officer. The planning board is legally binding on you if they're contrary to it. This board has the full legal authority within the jurisdiction that you voted on, and which is provided under the state law and under the UDRO, to affirm the decision, that is to say, planning board got it right, vacate the decision and have a remand to have further development, although I don't think that's necessary, or to reverse it. You have the legal right to reverse it, okay? And our contention is that the legal determinations here are not entitled to deference and are wrong. And so that's why we feel that's our position.
Okay.
And I would just refer back to what the UDRO itself says. When the Board of Appeals hears a decision of the planning board, this is from section 7C, it shall hold an appellate hearing, which is what we're discussing this evening, and may reverse the decision of the planning board only upon finding that the decision was contrary to specific provisions of the ordinance, matter of law, or contrary to the facts presented to the planning board. The Board of Appeals may only review the record of the proceedings before the planning board. The Board of Appeals shall not receive or consider any evidence which was not presented to the planning board, but the Board of Appeals may receive and consider written or oral arguments, which you will hear this evening. If the Board of Appeals determines that the record for planning board proceedings are inadequate, the Board of Appeals may remand the matter to the planning board for additional fact finding. So either reverse, affirm, or send it back for additional fact finding if it's necessary for you to determine whether the decision is supported by substantial evidence, if you don't understand what they did. So that's the standard of review. It's pretty straightforward.
That's what we just, yeah, we're in agreement about the standard review.
Okay.
There's no legal determinations are not binding on this board. Agreed?
We agree that this board is free to determine whether the planning board made the right call in applying the ordinance and state law to the application. That's part of your charge. So as you do this, there is one issue that was raised besides the four findings, and one of this was something that's in Norman Hanson Detroit's brief that was filed in support of the appeal. That's with regard to due process violation. Throughout the brief, there's an argument made that the appellant, and please understand, my role here is I am the neutral advisor to this board. I did not advise the planning board, I have not advised the code enforcement officer. I'm here representing this board, an impartial board, hearing this and granting a fair hearing. So if I mention the evidence below, I'm simply trying to summarize it for you, as you're going to hear a summary of the argument that Attorney Driscoll presents. So it's only in that matter that I mention these arguments. But the argument, as I've read it, is that by raising four specific UDRO road issues during the deliberation phase and not allowing the applicant's consultant, Mr. Duncan, to speak, the planning board deprived these parties of due process of law. That's the argument throughout, and Mr. Driscoll will make that argument, I'm quite sure, to the board on this point. Perhaps it's best if you hear that directly from him, and then I'll just recount to you my review advising the board as impartial counsel on it, if we're going to go down the due process road. Mr. Chairman,
yes.
If you'd like to hear Mr. Driscoll speak, to just address
Sure.
it.
Whatever you say.
No, go ahead.
Okay. All right, from a review of the record here and the proceedings before the planning board, it was obvious that there were these legal issues ever raised that these issues were present, or that, for instance, in the town of Newry, there's no such thing as a parking lot. There's only roads and driveways, okay? All right. So, and what my position is that if the appellant, Timberline, had been given the opportunity, and because the process is supposed to be collaborative, you submit your applications, they're reviewed for completeness. That's not to make a determination whether they're good, wrong, or indifferent, because you're gonna be hearing about it. But at a minimum, basic due process requires that you, from the adjudicative body, to articulate what the concerns are, because it gives the applicant notice and opportunity to be heard. That's the drift of it, and that's what we all believe in.
Mhm.
So we're saying, I don't think it's open to legitimate debate, that these issues concerning parking lot being a road or not being a road, or the access points being roads, or our parking spaces are treated as dead ends, were never raised. And accordingly, they were never responded to, okay? Same with the issue of the notion that the applicant would make an access to the property more non-conforming, right, because it would go two ways instead of one way. Now, what that fails to consider is that if they're given an opportunity to address the issues that apparently made a difference, as a full and fair opportunity, that's all we want, they could have responded, okay? And all of the legal arguments that my young lawyer wrote, and we've done all these cases that are cited, in those are cases that we did, okay, that deal with this, and we laid out what could have been raised before the planning board. Now, what that does, by laying down, not saying anything, and springing on it, it almost compels a court case, okay? And in a situation where it's happened before, okay? And with all due respect, there's no need of it, okay? You can be forthright, put your cards on the table, and give them an opportunity to respond to it. So in broad brush, that's our due process argument, and it's articulated, I think, very well in our brief.
No, I read it all. I did not look up those other cases, but
Yeah,
I'm sure that.
Jim will tell you that they're accurately cited.
Yeah. Again, I wanna just go back to what I said about the amount of information that they have to deal with at,
I get it. Yeah.
3 or 4 meetings, and not everything is gonna be covered 100%. Now, we do have a fire department letter in here, we have an engineering report from Gorel and Palmer, which all get turned in, after it was asked for. I mean, you get an engineering company on deck, and they go out and look at all of your information, and it takes, you've missed the board meeting already, and then you get information, and you get this packet in the next meeting, and you wanna get this thing going, and you wanna get it approved, and it takes a lot of time to hash all this stuff out. So it's very difficult to say that, it was sprung on you without any,
With respect.
but it could have been the sedimentation, then it could have been anything.
But it wasn't that. What it was this determination that a parking lot has to meet performance standards for a road. That's ridiculous. Okay? And that was the contention that was sprung on them, and it just has no support in the ordinance. One of the principles of construing any ordinance is to give words that are ordinary meaning and effect, and to construe it in a fashion not to create absurd results. And this is like a textbook case of absurd results. Is a parking space a dead end? That's a subsidiary conclusion of the planning board. Is an access point to where the roads are at grade, is that a road? It's not, and if this is a debate about, well, I don't agree with the sedimentation thing, and we have dueling experts, and the planning board made a decision weighing one expert more than the other, those are the kind of conclusions that are given deference, that you don't substitute your judgment for that of the planning board. Legal determinations are not binding on the case. If there's further appeals, legal determinations will be made in court. And with no deference given to the planning board, this talent is just the intermediate appellate, and it would be reviewed that way. And I stand on my submission that we accurately cited all the cases that we have, quoted word for word. These are cases that we've done. So, and they're cited in the brief.
And there were a lot of them.
They were. If I may, then, oh, I'm sorry, I'm meeting.
Go ahead.
So for the audio recorder, Rick Dunn with Mainland Development Consultants. In support of what Attorney Driscoll is referring to in regards to the springing of an issue on the applicant, I've presented projects to the town of Newry planning boards, different planning boards as they've come and gone over the years for 20 years now. This project is the first project that I've seen handled in the manner that it was. Meaning that all of the other projects prior, numerous, that I personally presented as an employee of Mainland and representing developers and folks who are trying to progress projects in the town of Newry. They were all reviewed in a collaborative manner with a back and forth between the applicant and the board. And so that's, there's a precedent there that was not followed in this previous review.
Okay.
And just to bring this back, I think we're talking right now about the due process argument. And the due process one is one that Mr. Driscoll notes has been raised in court, and he has raised it before, and it's for the courts. It's not for boards of appeals. The Board of Appeals is looking at the UDRO and is looking at the ordinance and is looking at what the planning board found, not whether due process rights in the Constitution of Maine or the federal Constitution were violated. And so that's for another day, to the extent it was preserved, since there were no objections made on the record to that. But first off, with regard to the letter that was offered by Mr. Bullen.
We're not presenting that. That's just a love for the right. That's excluded from the record, so.
Well, it's excluded from the record, but fine. Just that the Board of Appeals declines to receive that letter for review.
We have not seen it.
Yeah.
We didn't get
I
it.
don't know what they're declining, but sure.
Well,
That's right. That's what it is.
It would be part of a motion, because I'd ask you that you also deny the due process claims because you can't hear them. They aren't within your authority.
I don't agree with that.
I think it is. I think it's for the court on review. And these folks they're lay people who are administering the zoning and planning ordinances and appeals from them, but they don't wear black robes. And
They make legal determinations. The planning board made legal determination, and this is an appellate review, and legal determinations and factual determinations are made. We articulated the legal basis for it. There's been no response to it. Okay? So when you are in a case and someone's trying to exclude you from presenting evidence, okay, what the onus goes to the person who's the proponent of that evidence to say, if you had allowed me to speak, I would have done X, Y, Z. And that allows the appellate court to look at it. He's just made the argument that we waived a due process violation. When this gentleman raised his hand, said, wait a minute, he was ruled out of order, like this. Okay? And so precluded from making an offer of proof. That's a due process violation. Okay, so, and due process is, skip all the legal stuff. Everybody knows what it is. It's fair notice and an opportunity to be heard on the things that actually make a difference. And I don't think anybody looking at this can be satisfied that Timberline was given a fair opportunity to respond to the core legal determinations. And then when they were made, they were precluded from presenting an offer of proof.
I'm not here to represent the planning board. I'm here to advise the Board of Appeals. A statement was made that the appellant never had any notice that these issues were coming down the pike until the planning board went into deliberation. And as this board knows, when administrative bodies enter the deliberation phase, the public hearing is closed and the public does not speak unless asked to participate. There are exceptions where someone might say, wait a minute, you guys never discussed that before. And maybe you can speak then. But take a look at your record. Page 312. There is a memo, an email memo, from the code enforcement officer to Mr. Duncan and to Michael Barnes, also at Mainline Consulting. Last sentence. The road commissioners and fire department chief have an issue with all the driveway entrances onto Skiway Road and the parking lot 3 one-way access entrance. That's back on March 5th, and the hearing we're talking about was May 7th. I'm not making the argument, I'm just pointing out what's in the record. And if you take a look at the fire chief letter,
492.
that's page 492, that's correct. And that was April 7th, again, a month before the meeting that we talk about here. Dear Newry Planning Board, regarding the Timberline THLLC subdivision and site plan, tax map 03001A on Skiway Road, the many entrances into the property and the congested traffic that already exists at these multiple intersections, as well as the small parking areas for the buildings, is a concern for the Newry Fire Department. Section 14.68 requires a cul-de-sac or hammerhead turnaround for roads that dead end. The parking areas could be connected, so drive-through access is available for fire trucks and first responders for both the upper and lower accesses. The access way off Timberline Road and the entrance to parking lot 3/building 1 of the subdivision will require street names, new 911 addresses for the units, and must comply with the Newry addressing ordinance, and so therefore these access ways will become roads. Making the parking lot 3 access way a two-way road will also add more confusion to the 400 plus or minus foot section of Skiway Road that already has traffic moving to and from 5 different roads or access points, and as many as 40 vehicles backing out of the parking spots on Skiway Road's shoulder, plus all pedestrians coming and going from South Ridge. The Newry Fire Department asks for these standards to be thoroughly considered and public safety to be foremost in everyone's review. Thank you, Alan Fleet, Chief. Now, Coral Palmer also took a look at section 13.x in its memos and didn't have as much trouble with the proposed access points, but on the other hand, where there is conflicting evidence, the planning board can rely on one over the other, as Driscoll noted. Then take a look at page 505, and you'll see that Mr. Duncan was aware enough of the fire department letter that he responded in his revisions to submittal materials dated April 23, 2025, in advance of that May 7 meeting. So to say that they were never aware and sandbagged at the last minute, I'm not sure the record supports that. Again, I'm not making the planning board's argument, I'm simply pointing out that there's other material in the record to take a look at.
And unfortunately, I think as a board, this is what we need to go by, and there's definitions in there, and there's the differences between roadways and driveways, and,
Right.
you know, major subdivision, there's no such thing as a driveway, according to this thing.
Right.
And,
Right,
you know,
so,
believe me, I read the roadway stuff in here, I tried to skim the rest of it, but it's.
so my advice to the board is let's,
Actually, do you believe there's a definition of a roadway, of a driveway?
we'll get there.
So before we get into that, I do take exception with Attorney Katsikas' what appears to be somewhat biased opinion for the board. Agencies are consulted on a regular basis, whether it's town of Newry or other towns, and their opinions are considered by the board. Their opinions of those agencies only, and then it's for the board to make their own determination and discuss with the applicant, in my opinion, how the board feels about those opinions submitted by the agencies. And so while the agencies did submit the letters that Mr. Katsikas mentioned and read off, there was never mention from the board to the applicant as far as uniquely address a particular issue until denied. And that's
Again,
seemingly.
against the backdrop of, the kind of the physical reality out there, right? Because this parking lot is at grade all the way down. Right now, everybody goes over it every which way, okay? And having, two access points, instead of forcing it into one, you know, makes sense, okay? And so, why that's not enough to fill, that's what the ordinance says. The principle is that you need to construe the ordinance as to accomplish its basic objectives, okay? Which are articulated in how we cite them in the section of the proceedings, as well as the planning board relied on, which laid out some of this stuff. To avoid absurd, ridiculous results, or to have determination is made that, the most egregious in my view is that a parking space is at the end. You have to go in car wash.
Well, you say absurd, but I also think that when you look at that thing from the top view, if you had to get a fire truck into that back building or something, you're gonna have a hard time if those spaces are filled with cars, and that's
Just view
why
it
this
against,
stuff is in
if
place.
you view it against the existing conditions. There was a restaurant at a brewery, right? No defined ingress or egress. And this is a good project. It has the detail, it has the traffic flow. It meets the standards that actually exist, okay? There's nothing in here that says, a parking lot is a dead end, or parking spaces is a dead end, or that an access point is a road, and it has to meet the design standards of roads. It just doesn't say that.
Mr. Chair, a suggestion. There are 5 issues raised. One of them is violation of due process, and then the other 4 are the findings that were made by the planning board. My advice to this board as its neutral counsel is that you do not have the authority to decide due process claims. That's for a court. Attorney Driscoll disagrees. My advice to this board is to make a motion that it declines to accept and review the Exhibit E, June 12th, 2025 letter offered by the appellant.
We've already withdrawn that from the record.
I understand, but I want to make sure it's
For being recorded.
and that the board denies the due process claims because it does not have authority to hear.
If it has, in order to deny them, it has to have authority to make that decision, okay? You can't deny it and say, well, the whole point of due process is basic notice and opportunity to be heard. It's not that complicated.
Simply asking you to deny the claims because you don't have the authority to issue. That would be the motion, that's my
Let me put it
recommendation.
this way, say the board, this board weren't satisfied that an applicant was given fair notice of what was actually coming out. Wouldn't it be in the discretion of the panel to vacate and remand to go through that? Okay? In order for someone to evaluate a claim that there has been a denial of due process, they have to get into the merits of it, okay? And so, it's certainly, I don't think that you should do it, you should be straight up reversed, okay? But you have the legal authority to remand, okay, right?
They have the legal authority to remand it for additional factual findings if they find they're inadequate.
Order, okay. But you're not bound by legal determinations made by the planning board. I've heard nothing that says that you are, or that an access point is a road. I'd be very curious to see where that comes from. Or that a parking space is a dead end. You can search in vain through the UDRO for anything except that. So, I don't want to beat a dead horse, but point is, you know.
But my point is, my recommendation is to vote down the due process claims, and then we can move on to the 4 findings, and you can open the public hearing, and maybe you want to address each of those claims one by one, whatever makes most sense to the chair, to the board, efficiency-wise. But I recommend that you vote to deny the due process claims because we're without authority to adjudicate them.
Can I ask a question about if we, throw out considering the due process and basically grant your contention that due process was denied, doesn't that kind of like render the other 4 things, they're out as well? I mean, if due process was violated, then all that other stuff, it doesn't matter what they decided. Is that correct?
If due process were violated, it depends what a court might do, but a court might require it to go back to be reheard. But a court would do that.
You can do that too.
I don't believe you have that jurisdiction.
It says you have the capacity to remand to the planning board. What for?
The findings of fact where the additional findings or where the ones that were made were inadequate to permit judicial review or review by this board.
Well, and the denial of ability to submit an offer of proof as to what that would be is what we're talking about. He was ruled out of order like this.
But if you look at the recording, did not make an objection on the record.
What does this mean? I'm John Marotta, Timberline THC, for the record. I'm just
It was
curious.
after the,
During, well,
No, he wouldn't let him respond to a remark that he had made, which was, he had a good response for it.
yeah,
Nothing was asked prior to shutting the meeting down. Once he shut it down for deliberation, he came up with his own things that he said he doesn't like, and he wouldn't let Rick speak.
yeah.
Wave his finger
I'm
at
not at those meetings, I
That's all
get
right.
the minutes that,
That's fine.
That
You gotta go by the minutes, and it doesn't
Yeah.
show a finger wave at a kid like he's 6 years old.
yeah.
Right, it was not handled with due process or professionalism at all. So, I know you're gonna keep speaking for them and not let them speak, but
Well,
we'll move on, I won't say another word.
I do think, that there's a little bit of information in here about the roads that they had concerns with. To me, this is the biggest one that really doesn't say a lot of concern about the roads, but we do have this letter, and,
My email,
huh?
it's in my email.
Well, your emails, are those, we see those,
There's one that's in the
okay,
record.
yes, that one, yeah.
So in these things, Joel, with all the other condos that are up there, could you show me one that a fire truck can get in there and turn around?
I can't set, the
You can't.
precedent is not set by
Right,
planning
so
board.
all of a sudden we're setting precedent.
No, we're not.
Sounds
We're
like it.
following the ordinance.
You didn't do it before.
not-
That's the problem.
Well, this thing's been revised 10 times, and I don't know what the revisions are, at each one of those dates. But unfortunately, this is what I look at, and I try to find the definition of roadway, and I try to see, it's a major subdivision, and, am I a lawyer that writes this stuff? No, I'm not, and to me, does it make any sense? It may not make any sense, but this is what, I was told to go by. And, yeah, go ahead.
Yeah, thank you, Mr. Chairman. I'll note that in an attempt to satisfy the question posed by the fire department that the parking areas associated with the units were not fire accessible, Mainland submitted exhibits to the planning board, and they're part of the record, demonstrating that a 40-foot tanker truck can make turning movements in and out of all of the parking lots. So, what we expected, what I expected as part of that process was a board's deliberation on the merits of those exhibits.
Okay, so with that said, you're telling me that the cul-de-sac that they dimension all out and the hammerhead turn that they dimension all out is really, it's too big, it doesn't need to be that big, and I have to change the dimensions on this thing. I don't know, John.
Yeah.
I mean,
It's kind of common sense on some of this. It's not you just look at the letter of the law, you gotta throw a little bit of common sense into it, which seems to, we're having a hard time with here, that we have created something a lot better than what was there, a lot safer, a lot less traffic, and a lot less pedestrian people. So the safety issue has been taken care of. Common sense will show you that this development, compared to every single condominium complex up there, you have to go straight in, back straight out. There's guys here that plow those parking lots that can barely get their plow trucks down. We've made provisions for all that. We've made provisions to push snow and have safety vehicles get in. To go back to one entrance off of Timberline Road, you want to talk about him preaching safety, the planning board. You took away 4 entrances to get access to all around these buildings safely, quickly, and to take care of whatever situation you have to one way in, the back way in off of Timberline, which would maybe be the least turnaround area out of the whole development the way we're proposing. So that is the common sense part, that you don't always just look at, well, nope, that's what it says, you're done. That's not what a board should do. That's not what the town steward should do. I'm a town resident. You gotta look at the whole project as a whole. You gotta look at, is it safe? Is it better than what was there? Do we get great tax revenue from this and we don't have to do anything for it? Yes, it's a grand slam for the town business-wise. Safety-wise, we meet the things that Joelle was bringing up. 100% better than all the others. We've made those provisions. But we've never really gotten a chance to speak about it. And when we tried to, we were just shut down. Now the lawyer here will recite everything that's written down. My lawyer will recite everything that's written down and twist it. I don't really think it's a place for the lawyers. It's really not, because he's twisting it, and he is. It's up to guys with common sense who work in the business, who live in the community, who see what was up there, and they see what's going to be proposed to be up there. That is what's really being done. I know, I sat on a bunch of boards. I was chairperson of a lot of boards. I had to go by Robert's rules. This planning board, he doesn't know Robert's rules. It's his rules. It's not the Newry planning board.
Can we get back on the agenda?
So anyways,
Number 1.
Can we get back on the agenda was my question.
I believe he's speaking about due process.
yeah,
But we haven't,
so I'll get shut down again, thank you. But anyways, I'm all done speaking, I guess it's not really
Okay,
a
I'm
two-way
gonna
thing.
make a motion
Yeah.
that we
I'm done.
throw the due process out and we will vote on it.
Point of order. Ted Baker, Chairman of the Planning Board. A motion's being made. We're hearing an argument only from the appellant, and the Planning Board is not being given chance to explain its procedure that
Juries
is being
don't-
argued.
When cases are appealed, jurors don't testify to the appellate court what the deal was. It's totally inappropriate.
All right, this is a public hearing, members of the public can speak, Mr. Baker can at least speak on his own behalf, but also the Boards of Appeals ordinance, which many people don't seem to have reviewed, makes the planning board members interested parties, and interested parties are heard at planning board.
Many of them are here, I don't know if all of them are here, but
But I think whoever speaks, whether it's, the appellant, Mr. Baker, any member of the public, has to limit the arguments to what is in the record of decision, the record on appeal.
The point of your agenda refers to anybody who speaks can be questioned by the applicant, is that right? That's what it says, isn't it?
where are we looking?
State law gives everyone the right of cross-examination, whether or not it's actually a matter that's
I'm just saying.
appellant.
if both attorneys will allow me, I think we left off on open public hearing. The applicant is given the opportunity to present his case. So once you make a decision about due process item, I'd like to hear the applicant state his case why we're here tonight.
It would be in order for
Succinctly.
the public hearing to begin.
Yes.
And Mr. Baker, you want something to say on behalf of the planning board before we make a motion?
Mr. Chairman, if you're going to consider a motion on the due process, whether or not the board is going to allow it, I think it would be fair to have your opportunity to hear both points of views. Right now, you have heard solely from the appellant, and unfortunately, the town lawyer has to remain neutral on this matter and cannot represent the planning board. So right now, the planning board is being unrepresented, and you're making an motion to whether or not to consider the due process argument without having heard arguments from both sides. Thank you.
It's one thing for a resident of the community to get up and say what he or she thinks is appropriate. What Mr. Baker just said is that he wants to be the proponent of the viewpoint of the planning board, as if it's his, all right? That's totally inappropriate.
You want to make a motion and we vote on it? We vote to fill the due process out?
The due process is state.
It is. It is.
It's the whole thing.
But I think what Walter said is if we allow that, then the rest of it goes away. I understand what you're saying.
I mean, it says here, we have, I think we have the right to call anybody and ask anybody a question. I move that we hear from Ted Baker.
Okay, seconded. Okay. Vote. So,
They didn't say it out loud.
Aye.
what's that? We
Giving
make
the
a-
recording secretary blow by blow, that's all.
Okay. So, Mr. Baker, we're gonna let you speak.
When am I allowed to speak on, please, for clarification?
Only material that's pertinent to today's meeting.
Okay, but limited to the due process, or are we open?
That's what we're talking
Okay.
about.
On the issue of due process, the appellate would like you think, the Board of Appeals, to think that the planning board is a judiciary hearing, complete with rights for cross-examination, rebuttals, et cetera, when in fact, the planning board is an administrative hearing. We review an application that is submitted to the planning board, and for the planning board to raise concerns over possible issues with the ordinance would be totally inappropriate before we enter deliberation. Once deliberation is made, let me back up. This is an application. The burden of proof is on the applicant. What the applicant is asking is for a collaboration between the planning board and the applicant, and have the planning board act as a consultant and walk the applicant down the road hand in hand, saying, oh, you need to do this, you need to do that. That puts the planning board into a biased situation, because the next applicant may not get that same service or same consideration. And now they're feeling that they've been biased against because the planning board helped one applicant walk the process through approval, but didn't offer that same process to the other one. The other arguments I've heard was precedence. There is no such thing as precedence in a planning board review. We review the application submitted to the ordinance that we have in effect at that day. The fact that the applicant had two approved applications, one for a restaurant, which later expanded to a commercial business, and another one for a telecommunication tower facility, disappeared with the removal, or would-be removal, of both those structures. And in fact, including the parking lots related to those. So the planning board was approaching the review as that parcel of land being a vacant lot. No access ways whatsoever. And so any argument saying that we already had existing parking lots doesn't apply, because those went away with the old applications and the removal of those buildings. As for roads, there's a very important word in the word access way, and that's way. A way is the legal access from a road, be it private or public, to a dwelling. The UDRO is very clear. A driveway is a way that services no more than 2 dwelling units. The UDRO is also very clear that a road is any way, be it public or private, other than a driveway. So the planning board said, well, it's servicing more than 2 dwelling units. By the definitions that we are constrained by in the UDRO, it has to be a road. The fact that that road incorporates a parking lot is immaterial. It is a road. I also like to expound that the applicant is talking about making the property safer, but never mentions that there is a down the street, before you get to Timberline Road, a parking lot that holds in excess of 300 cars with a lot of pedestrian traffic that walks up Skiway Road to Southridge. So any driveway, access way, road emptying out onto that stretch of Skiway is an impediment to pedestrian safety. 2, the intersection, as stated in the
Point of order, are we on the due process? We're getting into the application.
Okay.
I have comments to respond.
Yes, yeah, just a second. Finish up what you want to say.
Okay, the intersection of Southridge Road, Skiway Road, and the access way to parking lot 3 does not conform with the intersection standards in today's ordinance. It is grandfathered. It was there prior to the adoption of the very first UDRO back in the early 1990s. Therefore, it exists. Improving the access way to parking lot 3 to make it a neighborhood road with 2 lanes would make an existing non-compliant situation even more non-compliant, in that it would encourage exiting of parking lot 3 down that way, which already happens, even though it has a do not enter sign. It would even be more so. So, last but not least, the appellant did not mention a court case that deals exactly with what we're doing here in due process for the planning board, and that was Fisher versus the Board of Environmental Protection, which occurred back in 1992. And it says that due process for a planning board, a review board, is nebulous. There is no right for an applicant to be heard. In fact, the main Freedom of Access Act allows the applicant to be in the room with us. It allows the applicant to record, take notes, take pictures. It does not allow the applicant the right to speak.
All right.
The king spoke.
Paul, go ahead.
All right, thank you.
The first observation was that the planning board doesn't do adjudicatory work. It considers application once it's flat wrong. The whole point of it is to come forward with evidence to have to make factual determinations and legal determinations and either grant or deny the application based on those submissions. That's basic, okay? And it should be obvious. It's also very nice to hear all of these comments now about what the thought process was. It would have been quite helpful to have it on the table so they could be responded to instead of like down after the fact and just, we're gonna take his word on it, okay? Bottom line is that it's not John Murata who's asking for the planning board to be, reasonable, or Julie Stevens, for it to be reasonable. It's the law. The process is about being collaborative, okay? Putting your stuff out there, being forthright, and telling the truth, all right? It's just that simple. And so if there was, they make all these claims now, and it's like, we're hearing about it now. Should be obvious.
Okay, thanks. I'm gonna make a motion that we throw the due process out, just so we can continue to go through the other findings of fact.
If you're,
I'm gonna make a motion that we throw the due process argument for now away, or not for now, but.
Sounds like you're terminating it. I'm not seconding it.
Okay.
You're not willing to conclude it.
let's,
For me, it's touch and go. I mean, the gentleman from mainland talking about his experience before planning boards. I used to be a builder. I've gone through a collaborative process when seeking an approval or a variance, try to get the ducks in a row. You don't want to submit something unless you have some pretty good idea you're gonna get approved. On the other hand, there is Joel's letter, there is Alan Fleet's letter, and there's also on, I think it's your revised submission. The S2.1 plan. It says paved driveway in 8 different spots.
Yeah.
And, it's not, we're not, ordinary people can say, yeah, driveway, but this is an official submission, details matter, precision matters. Agree with it or not, the ordinance says a driveway, you can't have a driveway if there are more than 2 units. And this says driveway. That did it all over the plan, so. That's why, I'm sympathetic to the claim of a violation of due process. Very sympathetic to it. I'm not sure it really holds up. And, what's your point on
Well, I agree. I went through all the definitions and I looked at the plans and, as far as the ordinance is concerned, it's a roadway. And I'm not saying that we need the hammerhead of the cul-de-sac, but you need a little bit of space for emergency vehicles to get in there.
that's Joel.
Huh?
That was addressed with a 40-foot line drive.
Right
Okay.
now, the issue is due process, whether or not the due process.
And we
claims-
have a motion.
And say, I'm sorry.
Well, that we're throwing the due process argument out. And if we don't, like you said, I think the rest of this stuff goes away. I mean, if we allow that, then,
The formal motion would be that the Board of Appeals rejects the due process arguments of the appellant because it does not have authority to adjudicate that dispute.
I object to that characterization of the law.
We'll find out later.
That's why I'm not seconding.
And I know you're not seconding it.
Well, I think there'll be disappointed people no matter what, right? The question here is, do you have legal authority? You have legal authority to determine whether the planning board made a correct decision on the law, the U.H.A.T state law. You have legal authority to determine whether the planning board's findings are supported by substantial evidence in the record. And if you don't find the substantial evidence that there isn't, one way or another, you can remand it for further findings.
But do we have the authority to say that they didn't get due process?
You don't have that authority under your ordinance.
That's what he
or under
says.
state law.
Okay,
If there's a way to cure this, to eliminate grounds for appeal, and we'll go that way, if that's what it comes down to, I've done it before. If there's, you could remand, and give everybody a fair opportunity to be heard on the subject matter, and to address the points. Okay? If you're sympathetic to the notion that we weren't told about this, and which we're told tonight, we didn't even have a right to speak. It's incredible.
Your conclusion in the brief pretty much spells it out.
Just to be honest with you, that was written by a very smart young guy. And so he's done all those other cases.
It just seems like you want a chance to represent
Well, I mean,
the plan and
well,
make it more safe or more
that's my
compatible to.
fair enough. But like, regardless of anything else, okay, you're gonna have to deal with the characterization of the parking spaces as being, okay, whereas access to a parking area as constituting a road, okay? That's going to be in this case all the way through. So, in my view of it is that if you're not going to reverse it, at a minimum, it should be remanded so that there's a full and fair opportunity to be heard on the matters that are actually germane to the rule.
And once you go through the 4 decisions, findings and conclusions of the board, you may find that you need additional information. And in that instance, you could remand it. So there would be a possibility.
Every one of those factual determinations was sprung on us afterwards. Okay? So this was, so there's going to be a remand, it's going to be about those issues. So we can do it one by one. It's the same thing. Okay, that's why we characterize it that way instead of just wasting a whole bunch of time in the brief. Okay, so we've laid it all out. Probably the safest thing to do is to remand it and have a motion opportunity to be heard.
Floor.
If you're not willing at this point to deal with the due process claims and move on to the substance of the appeal, which is my advice, then you can take that question of due process and hold it till the end and go in to the 4 findings and see whether you wind up in a space where you might be remanding it for additional findings or you might be reversing a decision. And then you can vote on the due process because it might not be even germane anymore. So how about, let's put that in the parking lot for now and move on to the feature attraction this evening, which is the 4 issues that were decided by the board.
you want to put that, the motion that we put that off until the end? That's item number 5. That would be item number 5.
That will be item number 5, okay?
Okay, all those in favor of putting that due process motion off until the end?
Aye.
Aye.
So now you may want to open the public hearing on the 4 issues, and whether you want to do them one at a time or all 4 together, that's up to the board as to what you determine is more efficient.
Well, it all has to do with parking and roadways and access.
Just for the purpose of this, the applicant was prepared to have it be consolidated. As I was saying before, all this permeates, this whole problem permeates all of those factual determinations.
Okay, so we can have discussion on all 4 of them together. I'll motion that we combine the four issues, finding of facts.
Second.
All in favor? Okay,
Now, up to you, open the public hearing and
okay, I'll open it up. Who would like to speak first?
It is detailed in your agenda.
Oh, gosh.
Thank you.
Joelle is thorough.
I'm trying hard.
All right, so tell me where I am. Open public hearing, then the applicant is given the opportunity to send a case.
Without interruption.
Yes.
All right.
Not finished.
Okay, well, I'm not gonna go through every finding of fact and conclusion, because all of the well, three of the four determinations stem from this notion that if it's not a driveway, it's gotta be a road. Okay? If it's a parking space, it's a dead end. Okay? Or an access point is a road. All of those contentions and claims are wrong, okay? And there is nothing in the ordinance that says so. Okay? And so, my perspective is that an access point to cross on the property is just that. It's not a road. It doesn't need to meet the performance standards of roads, because it's not one, okay? And parking space is not a dead end. We all know what a dead end is, okay? And your subdivision ordinance talks about roadways that go in, and it's an actual dead end with an empty, where it actually comes from an end. But, I mean, is this out here, is this a dead end? Where everybody's parking out, my truck's out over there? It's, gotta put it into the real world. That's what this is about. So, I am concerned about, I'll be honest with, I don't know if this is appropriate at this stage here. This is a remand. I have a grave concern about Mr. Baker's participation in the remand. I believe that's pretty obvious that he's biased against this application, and he feels personally attacked by it, and dug into the point where I actually said in this study that this is not adjudicatory and that Mr. Murata doesn't have a right to speak. Okay? So I'm very concerned about that. I want that about it.
Again, we weren't there. We got meeting minute notes, and that's all we.
You were here, you heard Mr. Baker. Okay?
Okay.
He said all those things.
Yeah.
Okay? Did that, they don't do adjudications. Okay? That Mr. Murata does not have a right to speak. Okay? That the DEP, that case he's referring to, talks about in a deliberation phase, after notice and opportunity to be heard, and the record's fully developed, you don't get to that to interrupt. Okay? Everybody knows that. That's all we're saying.
Every lawyer knows that.
Well, I mean,
Okay.
I mean, that's how this body transacts business.
Mm-hmm.
We knew exactly what was on the board when we came in here, okay? Joelle did a nice job, laid it all out, all the detail, that's what we're asking for.
Well, believe me, she put all this stuff together, and I'm amazed at the amount of work that went into it. I do want to say that I just got these minutes today, the agenda today, so,
Right.
Excuse me for not.
No, that's okay. That's all right.
I tried to move as much as I could, I did not. But, okay,
Yeah, I guess what I prefer is, rather than giving a soliloquy about how the project meets all the design criteria, I would like to have someone articulate to us how it does it. Okay? And put that out there so that, to the extent that it's a legal matter, I can respond to it, or it's a technical engineering matter, Rick can. Okay? I mean, you made a point earlier about the application refers to driveways, okay? Well, there's a reference to driveways in there. And I don't know if that's fortunate, unfortunate, whatever it is. The point is, it's not, okay? There's access points to a parking lot.
but they have definitions.
But the
And
part of-
whether they're right or wrong, or whether they make common sense, have any common sense or not, I mean, they spend a lot of time putting this stuff together, and it always comes down to somebody's perception of it, and somebody's understanding of what it should be or what it shouldn't be, but go ahead.
Yeah, if this is helpful, Mr. Chairman, if Mainland was to present a commercial application for a new restaurant, let's say, in the same space, I would submit that that use wouldn't qualify as a road or as a driveway. And so the absence of, what you might, as a board, think about and find that the absence of a definition for some other way that's not defined as a road or a driveway does not necessarily preclude the fact that entrance exists, that the ability to design such an entrance exists. And so that's, as an engineer, I felt like it was on me as an engineer to make a safe ingress and egress design, and we call it a driveway entrance to the buildings. Could be poor choice of words, given that there is a definition for driveway in the UDRL. You know, it might be better labeled on the plan as an access one. But the absence of that definition, we think ought not be the demonstration of it has to be one or the other.
Could you turn this to the page that shows the new driveway or parking situation?
Yep. It's all right, I'll stand right here next to you, and I apologize for blocking you.
I'm gonna stand over here.
That way I can, like a weather guy, I can try and point it in.
Am I allowed to ask questions of anybody here?
Yes.
Well, maybe somebody on planning can answer me the question of, it's my understanding that basically this whole lot, which Rigger said, since the other things went away, it's basically a vacant lot. My general understanding is, when you change your usage, any kind of grandfathered anything is out the window. Is that correct? Like, you can't say, oh, I'm starting over, I'm changing the usage, but I've got this grandfathered entry, or whatever it might be. If you're changing usage, non-conforming grandfathered stuff is out the window, is that correct?
Who are you addressing that to?
Either of you guys.
Well, let's back up a little bit. It's typical when you have a witness who's testifying, certainly you can ask questions of the witness, and then, each side can ask. And then once that's done and all the witnesses have spoken, if you still have questions and you want to direct a question to Mr. Baker or someone, or, Mr. Dutton or someone, then you do it. So if you have a question it would be appropriate to ask Mr. Dutton any questions he might have for him at this point.
So, for my part, I could answer that in that, I think if the grandfathering was germane to both uses, it seems to me that it would be plausible for that grandfathering to remain.
Okay.
Some municipalities have ordinances that provide the loss of for instance, a non-conforming structure is demolished by a storm or something. It doesn't just evaporate.
Right.
There's a period of time where it is ordinance driven, and that's it.
Okay.
Is there anything else I can, so, if it's helpful, the gray areas, if it wasn't clear, are intended as paved access for parking areas.
Right.
The buildings are these big bold lines, right? So there's 1, 2, 3 buildings, and then access points on Skiway Road 1 and 2, access way on the existing parking lot, free access, as Mr. Baker noted, and then an access to Timberline Road. And again, that's all in an effort to provide access to both the front and the rear of the building for convenience.
Now, also in the revised submission, fire department letter, you know, you try to address, the concerns. And item 2 here, it says the parking areas could be connected, so drive-through access is available for fire trucks and first responders for both upper and lower access. So again, this goes to kind of, you guys knew this was an issue. But I'm curious, it says here, to do that would be challenging, I think is the word to use.
Because of the grade issues.
Yeah.
Sure. Yeah.
How challenging? And, you know, some challenging that it couldn't happen. I mean, I look at it as somebody, you know, and to me, it seems a simple good solution is to keep that access to the parking lot one way and then connect the back lots. So, and possibly we make that one way, so people just come in and then they go out onto Timberline. That helps a lot with sort of traffic flow, you know. And I don't know. But it seems to me, again, going to the collaborative process with code enforcement or planning or however you like to do it, in my experience, a conversation about exactly that sort of like, okay, yeah, this isn't gonna really satisfy us. Let's look at other solutions. And I'm curious, it seems like the proposal to have it be a, you know, drive-through, like you mentioned, oh, this is not a dead end. Well, this is a drive-through. Someone can drive right around. And to me, particularly up there, which is, you know, the highest traffic volume, certainly in Newry and possibly Oxford County, I don't know, you know, on some days, that's more traffic volume than we'll see anywhere. So I would think, I would think that, you know, real attention to traffic flow would be paramount. And then also, in my life, I do what Alan Fleet suggests. Yeah.
That's me, can I respond?
Yeah, please
Yeah.
do.
So I appreciate those comments and those perspectives. And I think you're right, that it's difficult but not impossible. So in the spirit of collaboration, what we would have liked to have gotten from the board was a comment of, you know, it might sound something like this. In your recent submittal, you countered, I think it was the paragraph that you're referencing. I think I'm responding to the fire department's
Yeah.
concerns.
Yeah.
And so this is for the again, the agency presents their concerns. We are giving our 2 cents on the concerns, and then hoping for the board's review of, do you feel like those concerns are valid and should be dealt with by the board or not?
Just as an aside, the way you framed it is exactly the way we wanted it.
Exactly, that's exactly where I was.
Nothing complicated.
And so, given the opportunity to discuss that with the board, there might have been an opportunity for a difficult connection, albeit, or a connection albeit difficult. I have a little bit of concern over breakover grades for the longer fire trucks. We have to worry about, are they gonna scrape as they're going down so that could work for a passenger car, perhaps, not as well for the fire truck. But all things that we would have expected dialogue on, and and the ability to work with the board toward what they think is the best solution for Newry, as well as the applicant and interpretation of the UDRO.
Thank you.
I'll set?
Yeah, and that was a great answer. But in terms of any other questions that you have, we're perfectly
Well,
prepared to respond.
I was just gonna open up to anyone else that wanted to speak.
Have we satisfied letting the applicant speak
That's what I just,
100%, you know?
yeah,
But we're done, yeah.
Okay,
If there aren't
okay, I
specific
just want to
questions.
stay on the
okay.
agenda.
Yeah. Anyone else interested party would like to speak and say anything at this point? Go ahead.
I'm not a resident of Newry. Do I have your permission to speak? Sherry Thurston.
I don't know how that works. Right.
So public hearing, you hear from the public and take it for what it's worth, given who person.
Sherry, you have my permission to speak, how about that?
Thank you. I'm the former Bethel Planning Board Chair for quite a long time. I worked with Mr. Murad on 3 projects. I'm here on his behalf. Professional, great care was given to how anything fit into our community. Always a pleasure to work with. So I was very surprised to hear that this happened. And he always came with Mr. Dutton, so it just has not been my experience at all.
Well, I will add too, I've known John a few years. I mean, I'm an I hope contractor and, and yeah, I mean, I never heard anything bad about any of the work he's done or anything else, and I certainly respect the job that he does.
Just to put it out there, Beth and I bought one of his houses.
There you go.
We loved it.
There you go.
And you're still talking.
Yeah. That's a good thing. Anyone else? You're next.
Okay.
Any other interested? Yeah, go ahead, Mr. Baker.
Ted Baker, Chair of the Planning Board. The Planning Board is charged with applying the ordinance as written to an application. A character witness or the characterization of the applicant has no place in that review, whether it is a gold star contractor or a one-star contractor. That's immaterial. I hear a lot about collaboration. I again emphasize that the planning board is a review board. It was made very clear to the applicant way back at the very beginning that the review process is the twofold process. The board will first review the application for completeness with no judgment whatsoever to what was submitted as to being in conformance or not conformance. Only that the board had sufficient evidence submitted to it to be able to apply the ordinance to see if it complies. Once that application is found complete, the applicant again was advised that once completeness is determined, that the board would frown upon any major change to the application, because that just puts us right back to square one. And the burden of proof, as per the UDRO, is on the applicant. The planning board is not a consultant, nor does it have nor should it be rendering opinions prior to deliberation. That is a violation of due process, which has been battered around here quite a bit tonight. But to have a planning board say prior to determination of completion, hey, we have problems that this doesn't comply with the ordinance, that in fact is a deliberation. We have made an opinion. That is inappropriate. The board is to remain neutral until the application is determined complete, and then it sits down and applies the ordinance. Also, at every single meeting, I open the meeting reciting the state freedom of access law to everybody that's in the audience. And that law states that you have the right to attend the meeting, you have the right to record the meeting, video and audio, and you have the right to take notes. you don't necessarily have the right to address the board when it's in deliberation, when it's in a working meeting. That's only in a public hearing. And there was a public hearing on this case. It was held on the 17th of May. And as was the site walk. And we went into deliberations right after that. So for a planning board to be business friendly and collaborate with an applicant is actually taking the burden off of mainland development, in this case, to do their due diligence and to prepare an adequate application that holds water. It's not the planning board's responsibility to say you have a hole here and you're leaking over here. It's the planning board's responsibility to take an application as submitted and to see if it meets the ordinance. Thank you.
Okay. Any other interested parties? Are we going back to the initial?
I'd like to refute some of
I'd
what Rick
Could I
said.
speak? I mean,
No?
no?
Not yet.
Okay, well, I just wanted to get my hand up, that's all.
Okay, go ahead, Joel.
I just want to stand up.
So, Rick, I have a couple of questions about what you were talking about in that the turnaround for the truck and the traffic on Exhibit 1, which is in that drawing. Do you have Exhibit 1 plan or EX1?
I should have.
Okay. So the size truck that they're using for this meets all three of our largest trucks. So he's got the biggest truck he can get on there for the town of Newry. We're good there. The issue I have is, I'll start on the left side of the page with the entrance off the access way to parking lot 3. That doesn't meet the ordinance. It says that at the greatest degree that is supposed to be is 80%. We'd like 90% intersections, they're the safest according to DOT, so on and so forth. But the ordinance allows for 80 degrees. That looks like it's a lot greater than 80 degrees. And then coming across the page, top parking lot for building number 3, the hammerhead does not meet the ordinance. It's only 40 feet long, or less than 40 feet long, and it just looks like it's the wheel width of the tires on the truck. The ordinance calls for a 60-foot hammerhead and then 20 feet all the way around it for a right-of-way. I'm assuming for snow removal. I wasn't there when the exhibit was added to the ordinance, but I'm gonna assume that for this area it's for snow removal. The only other thing that I see that I don't think was taken into consideration, and Mainland's well aware of what we look like in winter, especially our parking lots. Whether these units, the covenants do state them that they're not supposed to be rented. But let's just say I buy a unit in 2. I'm gonna buy a middle unit. There's limited parking in that parking lot. So I've got 4 friends driving up from Boston. They're all gonna bring their own car, because why wouldn't they? They're all gonna start parking on that back northerly edge of the parking lot. That takes away the ability for the fire truck to move around. And again, add snow removal. For everybody in the room that does plowing, you all know what that parking lot's gonna look like. It's gonna get tight, it's gonna be bucket loader. So those are the couple of things I picked up real quick looking at just this print. I think the hammerhead's not adequate size, does not meet the ordinance, and the entrance off parking lot 3 is greater than 80 degrees.
Go ahead.
I appreciate those comments, and again, would have loved the opportunity to discuss that with the board in the proceeding. The dimensions of the hammerhead, I would say, goes back to the issue of, is it a road or not, or is it a
The notion that it doesn't comply assumes within it that it's a road. A point that we've made at length, it's not a road, it's
but certainly we want to have a good way for the fire truck to get in, access, do what it needs to do, and get back out. And so that was the intent of this plan, and I think it's well achieved by this plan to show how the truck has maneuverability. And I'll note that it excludes vehicles parked in order to make that turnaround movement. The issue of will there be more folks here than the planned parking? That's, I'm sorry?
Well,
Sure, so, the association, the condo association, has the ability to enforce parking rules. And if it were the board's, the board's determination, I'm gonna say in this case, this board, if it had been the planning board's determination that, that limitation to the parking to the spaces shown on the plan would need to be, stated as part of the approval, so be
Fully
it.
expect that to be, in the regular condition of approval for any project. Yeah. I'm told that.
And then again, to the comment on the degree of, intersection, whether it's 90 degrees or more than 90 degrees, absolutely, it's much more, I think it's more comfortable to navigate for that emergency vehicle to navigate, in the direction of sweep that is shown, so it's practically designed. But if you're going to consider that access a road, then it doesn't meet the 90 degree or within some, I think there is a variance from the 90 degree allowed up to, I think, 80
80, yeah,
degrees.
80
yeah.
degrees, yeah.
But the point is that it's not considered a road. It's a nice, big, wide swing that enhances the safety of the project.
Right. So
I
what,
would love to deviate from what's written on these pages, but that's not, I don't get a vote, as I've said many times to Rick.
yeah, understood.
And
So-
again, that's what we have to look at.
Well, I mean, there is a whole section about parking, on page 131, it does sound to me, again, I'm not a lawyer, and I just started reading this, a couple of weeks ago, but parking areas design standards, the planning board may require that certain areas be maintained for firefighting or other emergency purposes.
That's what we're talking about.
Yeah, yeah, yeah.
And I think Joel's observing that it does.
There's, to the last point of snowbanks and all of that, oh, I'm sorry, were you done? Did I cut you off?
I'm just saying that I think that, well, maybe I misunderstood you, because I thought you had all along been saying, you got two choices, a driveway or a road, and there's nothing in the
No,
UDO
no,
about
that's-
parking spaces.
That's what Mr.
Parking,
Baker does.
okay. But I mean, that, and so it's as yet to be determined, I guess, whether any of that meets or satisfied,
Yeah.
what the UDO
If you determine
warrants
that
for
it's not a,
parking
if
areas.
you determine that it's not a road, okay, which I don't think is pretty hard to do, then you can say, does the ordinance say, okay, in parking areas, which is what this is, what do you consider? And that's exactly the point Joel was making, right?
Room for light trucks.
Yeah.
But if it's a road, it does not meet our standards.
So it
That's
comes
the
down,
other- I'll
comes
make it
down
2
to
points.
definition.
Yeah.
Right, yeah.
And if it's helpful to continue, in the discussion of snowbanks, snow removal is, again, planned, and also the responsibility of the association, and we've, provided on site plan 2.1, I think is where it is, a generous snow storage area, which a lot of these developments don't have. So it's not for me to editorialize on that. Lots of plans with this. There, so there's a generous snow storage area in here, so that those banks can be removed and put into an area where it's not gonna be detrimental to the development. But all things that what I would say is, folks like to talk about a plan or a set of plans or an application, meeting an ordinance. If what's submitted meets the ordinance, the letter of the law, then the application 100% should go through as determined by the board. And it's a nice sentiment, but for those of us who prepare engineered plans and prepare applications, we know that there's gray areas. There's areas of interpretation that we undertake with the board. And so there, in any set of plans, there's gonna be areas where we make calls on what do we think is the safest, what do we think is the best, the best interpretation of what the ordinance is looking for, what the community is looking for.
Yeah, and the lawful case law that says it's true that not to create absurd results and to implement the policies of the land use ordinance in the first instance. I'd like to make an observation too about that it would be a due process violation on hearing for someone to say, hey, I think you're weak in this specific area. I was admitted to the bar in 1981. Okay? I've been working full time as a lawyer from then to right now. I've done hundreds of trials, non-jury trials, AD appeals, and a few jury trials. And in any of those cases where you're in front of a fact finder, I routinely get a judge saying, I've heard this, I've heard that, I want to hear this. Okay? And I don't know if that's collaboration or just a regular give and take of how people present cases and try things. There's nothing inappropriate about a judge doing that. My wife's a retired judge. She's a non-combatant and recovering lawyer. Okay? But the point is that all these things, it's the way you want regular disputes resolved. Okay? And so instead of this gotcha graph, I mean, all of these points, all of the very considered thoughtful points we've raised, and I've heard from Mr. Berry and Mr. Nelson, all things that could have been done. In terms of like, okay, well, what's our core beef with John Morales' application? And with respect, whether he's a gold standard or not, does have a bearing on approval process. One of the whole determinations routinely made in zoning and permitting is capacity, experience, okay, track record of violations, and they will find any on it. So Mr. Baker's wrong about that.
Comment again.
I appreciate the time. What was just discussed, it brought up another thing in my mind, and I'll be really vulnerable with the board. I always felt challenged by the assertion that once the application was deemed complete, that there would be no further back and forth with the board. I chose not to bring that up as an issue during those proceedings, mostly because I had faith in a process that I had seen play out many times. And I thought that deliberation was going to happen. And I think that the biggest thing that I can show to demonstrate how that's confusing for an applicant is that after a finding of completeness, there was still review by the board's third-party engineer. So the board was accepting review by the third-party engineer and responses from mainlands to those comments.
I think his terminology was major changes. We
Major,
didn't want
yeah.
to see major changes.
Exactly.
afterwards.
So-
There's room for,
Understood.
your collaboration, but
Yeah. Yeah, that the idea that it would be completely shut off, I didn't think that was gonna be the case, because, no one wants to see this come back as a restaurant instead of 3 condos, that's, and the idea that would still be complete as an application is absurd, right? I'm picking something that's way off the reservation to demonstrate the point, but, the idea that there would be some tweaks to the plan and the technical nature, like might be suggested by the third-party engineer, or that might be suggested by the board, who has, boards have good ideas and often find ways to improve plans. It was foreign to me that process did.
Other comments? Jack?
Hi, Jack Taylor, I'm a resident. I'm actually a former planning board member myself. Excuse the memory lapse here, but about 5 years. Becky was there. She might remember me. I'm in favor of this. It seems like it boils down to a matter of interpretation, and it can go either way. It's pretty sketchy that way, and I think moving forward in the years to come, Newry ought to nail that stuff down a little bit better with our town meetings, etc. We're looking at in excess of $100,000 in tax revenue generated off of this project. That's nothing to just laugh at over some semantics. When I was on the board, there were a lot of applications that came through this room, and we never turned one down. There was a lot of give and take. We worked with the applicant to make it better for the town and the applicant, so that the end result was they got their project, and we were happy with how it happened. And I don't see that happening now, and it makes me sad, honestly. Thank you.
Anyone else, Mr. Baker?
I'd just like to comment that the decision is parking lot or road. What the appellant is failing to say is that the way to get to these dwellings, the way, just happens to go through a parking lot. There is no other way to these 11 dwelling units that they're proposing other than these access ways that just happen to incorporate a parking lot. They are not parking lots, they are ways. And according to that determination, by the definition of the planning in the UDRO, a way is either a driveway or a road. It's no buts about it, one or the other. Thank you.
Okay. Anyone else?
It's up to you whether I'm allowed to speak or not.
We let your wife speak, I guess we don't.
Try and stop her. Sorry, honey. Well, I am a layman, I'm Tony Andrews, and hopefully, like you, will be a former builder. My only comment is the term collaboration is really getting beat up here. I don't think it's a swear word. I don't think you should fill out their applications for them, but I do feel like the job and duty of a board is to act on the best behalf of the people they're representing. So I think it behooves people to perhaps allow adjustments and not get all hung up on legal details that you guys can battle out, and I totally don't understand. But I do feel like it requires a certain amount of common sense and looking at it like, is this project a good project for this town? Does it have detrimental aspects? Does it have positives? And in weighing those things, I think at times you're going to have some back and forth. When that gets circumvented, or appears to be circumvented, everyone digs their heels in. I don't think it's in service of the community. That would be my only take on it.
Thank you. Anyone else?
What is, I don't want to speak out of turn. One of the points was raised, if cases that we cited are called zapping. Instead of exactly that, if you go through the process of this ambiguous term in the that has impairs the ability of the property owner to get approval, that ambiguous term falls off. Tie goes to the landowner. No way of it.
Okay, thank you. Go ahead.
If I make 2 points. There was a finding made by the planning board, and that's finding of fact number 1, and number 2 in that conclusion, that the hammerhead that was proposed on this was not in conformity with the ordinance. Hammerhead is necessary for the turnaround if you consider this to be a road. We have a dispute there, we'll get there in a minute. The decision was made on the basis of the April 7th letter of the fire chief. At that time, the plan before the planning board did not have a hammerhead. But the night of the meeting, or in advance of that, Mainland submitted a plan, well, actually the whole plan set, in advance of that, which showed a hammerhead. No one ever measured that hammerhead at the planning board level to determine whether it actually met the standard or not. That's something that, although the CEO has talked about it this evening, it's not in the record. The planning board never did it, so there's no determination by the planning board that this hammerhead that was shown on the final plans that was submitted for consideration did or didn't meet the standard. So one could argue that you have inadequate findings and therefore would remand it to the planning board to take a look at this issue and get back to you. That presupposes that this is a road that requires a hammerhead. So let's talk about roads for a minute. If I have a lot, and I put a house on it, I probably need access and frontage on a house, on a road, right? I need street frontage. I need to be able to have access. But how do I get from the road to my house? I put a driveway up to my garage. It's a driveway. Okay, suppose that instead of having a house, I have a condo in a multi-unit condo building. Well, under this ordinance, the driveway isn't going to suffice anymore because it's serving more than 2 dwelling units. What do I need? The only other access available under the new drill is a road. So, again, I am not representing the board, the planning board, but it's been argued that the construction used by the planning board leads to an absurd result. It doesn't. I don't know if many of you've been into Rock Road in Portland, in Westbrook, actually, Rock Road. Probably shopped at Market Basket, right? You may have. If you shopped at Market Basket, how do you get there from State Route 25, Main Street, which is the access to the whole development? On a road. It's a road built to road standards, or a private road, but road standards under the Westbrook zoning ordinance and planning ordinance. Now, you could argue that's Westbrook. We're in Newry. But in Newry, you have to get there from here to the building that you're building. And it's the only 2 options under your ordinance are driveway or a road. So if it's a road, then the road has to meet road standards. If you dead end it at a parking lot, then there has to be a turnaround under the ordinance. It has to meet the standards for a road. There are several categories. Neighborhood road is what was looked at here. So, if you assume this is a road, and that the board is correct in determining that it either has to be a road or a driveway, or you can't get there from here. You can build a parking lot and you can't daylight onto a public road. If you believe that's correct, then it has to meet the standards, but they did not tell you whether or not this turnaround meets the standard. So we remanded for that, and the planning board is free to take such other action as it wishes on other evidence as it wishes, however it deems appropriate on remand. You can put that in your order. So that's one possibility as to how to approach this. If instead you want to go down it's neither a road nor a driveway, and therefore there are no standards, that's your determination as a board. You get to look at the ordinance and how it was interpreted and applied by the planning board.
with respect to the latter point, it's not, we're saying parking lots have no standards. Parking lots do have standards. They're referred to in the UDRO. We meet those standards. So, do
I beg to differ.
How so?
Item 6.
Excuse me, Rick, can you tell me
I'll
what
read
you're
it, yeah. It
saying?
says,
Okay, thank you.
Where development will abut an existing or potential parking area, provision shall be made for internal vehicular connections that allow vehicles to move between parking areas and lots without having to enter the road. That's what this one does.
I don't see them connecting.
It says,
It's coming off lot 3, right? Parking lot 3 of Sunday River,
yep,
an existing parking lot. Now the back two should connect. The planning board missed that. That would be a solution too. A very easy one.
well, to be honest, I mean, it's not like, it's, I was trying to find the wording of these laws, it's not collaboration, but the idea is to put out what your concerns are. Right?
Yeah.
That's all for us.
Yeah, that's what I said, and your young guys agree. He's just looking for cooperation.
He's smarter than I am. A lot of people are.
I don't like wasting people's time.
Yeah. Right.
I mean, let's find a solution.
One more
We can
comment.
do something about it.
Go ahead.
Hi, Becky Bean. I'm actually not a resident of Newry. I live in Hanover, but I just do the planning board minutes. I'm an employee of the town. But I just wanted the talk about doing what's right for the community and such. The ordinance is what the community has voted on and passed and accepted. And that directs the planning board how to review applications. So if the planning board is upholding the ordinance, they are in essence supporting your community, is how I see it.
I'm gonna tag off Becky on that
Go
one.
ahead.
Unfortunately, fortunately, there's other boards in town that have to worry about tax assessments and what the taxes are to this town. Nowhere in the UDRO is that part of our consideration.
Bruce?
Bruce Pierce, former planning board member. I was on the planning board when this application came through, and I knew we did the site visit. And I do remember asking because of that back lot and the whole hammerhead, and there is specific specifications for a hammerhead in the UDRO to meet the requirements of our trucks. But I had asked about, well, why don't you just make it go right up in through lot 3? And it was like, well, it'll be too difficult. And basically is what I got. So, and I didn't really push the issue, so we said.
That's a grade issue? Is that what it said?
Yeah, there's significant grade, although not shown on this particular plan, between the parking lots for unit 2 and our building number 3. It's not impossible to connect for the purposes of passenger cars. Though
Yeah,
it
but-
would be
yeah.
difficult to have an access that's navigable by a fire truck with a fairly long wheelbase. There's potential that's either extremely difficult or impossible based on breakable grades, and I don't know the answer yet. I'd have to dig much further. So they're kind of two separate issues, right? Does the emergency vehicle have a way to get in to all sides of the building to do what it needs to do? Or is it a question of safety of access of the passenger vehicles and whether or not they go through the parking lots and whatnot? There's certainly much more potential for that.
Okay. Anyone else with any comments? Can I close it for comments?
What's your agenda say?
My agenda says that at some point we have to go back to the due process
So you are down, you've opened up the public hearing, the applicant's been given the opportunity to
Right.
present their case, you've had a bunch of
Rebuttal
interested.
statements have been made.
Yeah. The appellate has asked questions of us. You guys satisfied with that? All parties may refute or rebut. I think you've handled that. And the board shall receive comments and questions from all observers and interested citizens. So I think
And
you've
we've done all
fulfilled
that.
all of that.
Okay,
yes.
but before I go to close the public hearing, we have to go back to
Well,
number 5.
you can deal with that in your deliberations.
We can?
I think so.
What are you referring to, the due process?
I am. That we put
Yeah,
off till the
I,
end.
Jim is probably, it's a